Former President Jacob Zuma's bid to privately prosecute a successor will return to the High Court in Johannesburg on the 6th of August. This as the former president still has pending appeals that need to be concluded for the matter to be heard in the criminal court. He accuses President Cyril Ramaphosa of being an accessory after the fact for failing to take action against arms deal case prosecutor Billy Downer, whom he accuses of leaking his medical records to a journalist. Joining me now was legal expert Mpumelelo Zikalala. Mpumelelo, appreciate your time. What are the legal grounds for former President Zuma's private prosecution bid against President Ramaphosa, and how have they evolved since its inception?
Good afternoon to you and also to you. Because basically when it was starting, it was saying, well, Mr. President, you as the individual that is responsible for the performance of all the departments and all the entities under your government, when a certain complaint has been made to you, you ought to have taken action and made sure that this particular prosecution was taking place against Advocate Billy Downer and especially Advocate Billy Downer when the complaint was filed. Now, your failure to take action is leading me to conclude to the fact that you are now an accessory after the fact. You are part and parcel of whatever illegalities that have taken place. You are part and parcel of whatever illegal acts that have taken place. Now, with the president responding or in the following manner in terms of saying, but I do not get involved in the issues of the NPA. There's an NPA head, Advocate Patway. That's the person that you report to. If there's anything to do with the conduct of the legal practitioner within the NPA, then there's the LPC. So I do not get into those particular issues. And if you come to me, there's nothing that I can do because I don't even control who should be prosecuted and who cannot be prosecuted. It's how things ought to be. So that's all the basis in which then I think the Gauteng High Court not only dismissed this matter for lack of urgency, that it wasn't urgent, it also brought into the merits to say whatever prosecution that should have taken place, no prosecution should be entertained, and that's where the story is going to end. Now, that's where we are now, because we need the pronouncement of the SCA to either say we are confirming what the protocol stated, or we are agreeing with you, former president. You can go on and prosecute Cyril Ramaphosa as a private prosecutor.
So, unpack for us what accessory after the fact actually means. I mean, it's a pretty interesting term, but how do you explain it to the layman?
It basically said there's a main act or a main criminal conduct that has taken place, and someone has participated in that, not the main conduct as such, but has added on to the illegality or to the criminal conduct that has taken place. So if you then, maybe someone has stolen something and you part and parcel in terms of concealing the information from the police, making sure that they are not caught, you are then becoming accessory after the fact. So you are not the main player. However, you played an integral role in making sure that the legality or the legal act continued and someone has suffered prejudice based on what you have done. So from the side of the former president, I think he was saying, or his legal point would have been, well, Mr. President, you ought to have acted in this situation. If you had acted in a time in which I had filed my complaint, we wouldn't be here in this case today because my complaint would have been dealt with. The mere fact that you have done so, indirectly you are telling me that you are part and parcel of the illegality that is taking place, the ill conduct which is taking place, or the breaking of the NPA code of conduct. Hence why I want you to be part and parcel as I'm privately prosecuting Advocate Billy Downer, because I think you may have been acting in concert with him, or even if not so, indirectly you participated and aided his bad or allegedly bad conduct that he engaged in.
Mpumelelo, how does the ongoing legal battle between Zuma and Ramaphosa reflect broader tensions within South African politics and the justice system? I mean, you can literally count on one hand the number of times that a former head of state has had to go to court this many times.
I would say maybe on a political level there may be instances in which they are not saying eye to eye, and there may be other utterances that have been made, especially by the former president, to say this is where I stand when it comes to President Cyril Ramaphosa. But going to court, if ever there's a dispute between two individuals, no matter whether they like each other or not, the court is the only forum in which they can be able to go and settle that disputes. The mere fact that mediation has failed and they've come to the point in which they need an external presiding officer to settle their scores once and for all is part and parcel of our dispute resolution mechanism, which is available to us. So I always say, everyone can go to court if they so wish, but whether they're going to win or not, it depends whether your case is strong or not. But We cannot force someone from wanting to exercise and defend their rights. We cannot force someone from wanting to utilize our courts to make sure that they're able to entrench the rights which are applicable to them. In this case, the former president has gone to court a number of times to say, this is how I want things to be. Has even made sure there's a private prosecution continuing against certain individuals. And even the current president, Mr. Cyril Ramaphosa, has gone to court to say, I want you to defend my right. I'm being prosecuted illegally. I'm being prosecuted or someone is misinterpreting the right to prosecute and the certificate that was given to them. Please protect my interests and rights. And the courts on other occasions have been there today to be able to determine whether what has been happening is okay and whether if it's not okay, appropriate relief has been issued. Hence why you see certain individuals, if they're not happy with the outcome, they go to higher courts to try and seek an alternative or a relief which is going to be different that they've received earlier.
Well, former President Jacob Zuma was in the courts a few days ago and came out victorious. One of the few times in the last few months that he's enjoyed any sense of victory in the courts. Now, how does the interpretation of Section 47(1)(e) of the Constitution affect the eligibility of convicted individuals like Zuma to hold office? And what are the arguments presented by both sides in this matter that we've recently witnessed?
Now, in this matter, it's important for us to look at it for 3 points of view. First one, the literal interpretation of the section 47, because it basically says, if you've been convicted without an option of a fine for an amount of time which is more than 12 months, then you are not eligible to be part of the list which is going to go to the National Assembly for the next 5 years since the date of your conviction. Now, what is unique in this case and what the former president was arguing is that, yes, I may have been convicted. However, there was an issue or there was an act which was performed by the president who was authorized by Section 88 to conduct that particular act or the functions and powers of the president, and they then applied what is called a remission. Now, my interpretation of a remission then simply says, my sentence which was given to me, which is not 15 months, was then reduced from the normal 15 months that I reduced to the number of times in which the remission was then applied, because the literal interpretation of a remission says that whatever amounts have been given to you, they are now taken back. Now, the notice period or the period in the remission was 24 months. It would have meant that the whole 15 months would have been covered. However, because the former president had spent 3 months in prison, that cannot apply retrospectively. So, in the literal sense, if you look at the records or what the records ought to reflect, they should say, you are convicted on this date, and your conviction, even though it was 3 months, or was 15 months, due to the remission, you are now left with 3 months, which is the time period which is going to appear on a criminal record. Thus making him qualified to be part of the National Assembly list, thus making him a candidate that can form part of it, even if he comes back with another part, or even as an independent candidate. Now, when you go to court, and one of the things which were being discussed about, or the point of contention, was the following. If you have a problem with me and someone has objected about me, you as a decision maker are supposed to give me an ear and say, this is an objection that you have received. Can you be able to respond to this so that I can be able to make an informed decision as the IEC? If you fail to do this, there's procedural unfairness that has taken place. Another point which was raised was that of biasness. You have someone that is pronounced earlier in January about a subject matter, then later comes up, and yet they are part and parcel of the decision-making process. What processes and what transparencies, practices can you be able to show me to say, when a decision was taken, that person did not form part and parcel because already they made up their mind as to how things are going to be. But the main one, which is very important, which I think maybe even the court looked at it, is to say, if you have two individuals that are going to suffer, let us look at what rights are going to be there or are going to be impacted. From the side of the former president, the Section 19 of the Constitution dealing with political rights, you can't play around with that right. You have to make sure that you protect it at all times. And even if it's to the interpretation of any action or any section that is there, if something is going to infringe that particular right, something that must be clear, something that must be even on its literal interpretation, you can see that a transgression has taken place. So even if we err, let's err on the side of caution by saying, Mr. President, we are going to protect your Section 19 right at all costs. You can go and be able to participate in the electoral process of South Africa. You can then be nominated to be a member of the National Assembly. Whatever other things that may come at a later stage will be adjudicated there. That's how I think the court looked at it from this matter to say, no matter what happens, we cannot play around with this right. Let's allow the former president to be part of the list that goes to the National Assembly.
So what role does the Independent Electoral Commission play in interpreting and enforcing electoral laws? And how does its decision-making process impact the fairness and legitimacy of elections?
Now, they are on the vetting process. So before someone is able to get into the National Assembly, their task is to simply say, here are the names of that are there. Are there any objections that we're supposed to look at? Let's give those individuals a right of reply in terms of those objections, and then make a decision as the IEC to say, here are the individuals that are going to go to Parliament at the end of the day. I do not really buy into the argument that says it's the National Assembly that does it, because there's no mechanism that allows us as members of the public to comment on the members of the National Assembly or potential members of the National Assembly, either in the process in which they are being voted for or a process which is now administered by the IEC. So it's the IEC that does the sifting and vetting processes, and once that has been done, they hand over a list to the National Assembly of individuals that are eligible to be there and individuals that can be voted on. Which is why, by the way, the very first sitting is presided over by the Chief Justice, in which the very first individual who is chosen to make sure that that particular house or line of government is able to proceed is the Speaker. And then from the Speaker, you go to the President and all the other individuals that are spoken to. So the IEC is there to say, let us vet and make sure that people that are going to go to the National Assembly are eligible to be there, firstly, as per the Constitution, and also as per the Electoral Act. Secondly, is individuals that can be voted for at the end of the day to be by members of the public. And let's open up a window to say, if you have any dispute or any concerns about the potential members that have been put in there by the parties, speak now and say, these are our concerns that we have, so that you can be able to investigate whether your concern is political or is legitimate. If it is, then we are going to say, this person cannot be part and parcel of the list. They must be removed because, legally speaking, they are not supposed to be there.
So let's talk about the potential consequences of the lack of a full judgment from the Electoral Court regarding Zuma's eligibility to stand for public office. And how does this contribute to public confusion and skepticism? And does it pave way for continued appeals because there is no reason that has been given?
Yes, it does. First, you don't know where you faltered in terms of the arguments that you have raised in court. And if you don't know that, then it's not simple to attack the interpretation which was engaged in by the judges. So you need to know where you went wrong. You need to know what is agreed to and what exactly you need to attack. So what that means from a strategic level is that you must then put up your case as if you're quoting it for the first time. So when the IEC goes to court, they will prepare and raise the very same arguments that they've raised earlier. Maybe they can listen to what the judges were raising and sort of assume that these are the salient points in which maybe they needed clarity in. That's what we're going to focus on. But it does make the work of appealing any judgment that is there very difficult if you do not know the reasons of the judgment, because you do not have the systematic thinking of the judges. You do not have the things or even case law which was looked at. So you don't even know which opposing case law or case law which is for you going to pick and make sure that you are advancing when you go to the appeal to the appeal stage. So those are the disadvantages that are there. But again, I think what is a bit pressing, maybe it's a topic for another day, is the level in which the judiciary is applying or is responding to this particular judgment. So now we can be able to see why a judgment with reasons is so important, but most importantly, why must it be brought within the shortest amount of time which is available? Because it allows us as members of the public to say, I've looked at this judgment, I don't agree with it, hence I'm going to take it to an appeal. If there's going to be a vacuum and there's going to be a time in which I'm not able to do that, time is going, and my rights as a South African citizens cannot be explored. I cannot be able to take this matter further because I do not know why I received a no answer from a court. The sooner I know that, the sooner I'm able to take a decision whether I want to take it to an appeal or not.